Hello everyone, welcome back to a new post today. And today let's speak about a judgment of the Supreme Court which upheld the right to preserve the culture of Tamil Nadu with regard to animal related sports. So we all must have heard of this sport called as Jallikattu in Tamil Nadu, which is really played during the Pongal time, and also kambala in Karnataka. So we have various sports related to animals in various places where we hear of them during the harvest festival, that's like during Sankranti or Pongal. And one such issue went to the Supreme Court based on cruelty towards animals. So there was the Animal Welfare Board involved in this, and also an NGO which is related to the protection and prevention of cruelty to animals. So these two have now filed petitions in the Supreme Court against the amendments brought by governments of Tamil Nadu, Maharashtra and Karnataka, amending a law called as the Prevention of Cruelty to Animals Act 1960, which is a central law, and they have brought this amendments to allow the sport to be practiced in their states, that is Jallikattu in Tamil Nadu, Kambala in Karnataka and the bullock-cart race in Maharashtra. So these states base their arguments on the supporting arguments based on the basis of protection of culture under Article 29. So the Supreme Court has upheld this article along with the fundamental duties of 51A, G and H, and also says that it does not violate Article 14 and 21. So let's get into the issue quickly and just have a review of what was actually said. So we already know that India is a land of diverse cultures. We have various sports, and also we have to protect the animals from cruelty and protect the wildlife, which is one of fundamental duties as well. It is also an important part of the directive principles of state policy. So recently there is a central law which prevents cruelty to animals and protects the animals. There is also a board called as the Animal Welfare Board which functions at the center to protect and prevent cruelty to animals in the country. So this law is called as Prevention of Cruelty to Animals Act 1960, and recently the governments of Tamil Nadu, Karnataka and Maharashtra have brought amendments to this law to prevent cruelties and also to continue the sport. So let me just remind you that in a case called as the Nagaraja Welfare Board of India versus A Nagaraja case in 2014, Supreme Court had actually banned Jallikattu. So these amendments were brought to instead continue with the sport of Jallikattu, saying that it is a part of the culture of Tamil Nadu and also protects the livelihood and also preserves the traditional cattle breeds in the state. So these amendments were brought by Tamil Nadu to preserve Jallikattu, Karnataka, Kambala and Maharashtra the bullock-cart race. Now they want to preserve these animal races and the sports, and they say that it is a part of right to protect their own culture under Article 29. So they passed amendments in 2017 to a central law against cruelty to animals in order to allow the traditional sports such as taming of bulls during Pongal. Now this was done in 2017 after the 2014 banning by the Supreme Court, as I said recently, of Jallikattu in a case called as the Welfare Board of India versus the Nagaraja case. A constitution bench now has ruled that the changes made by these states in the law were valid. The judgment at that time banned Jallikattu because they found that the bulls were beaten, poked, prodded, harassed and also jumped on by numerous people. If you might have seen the television channel during those times, and it was clearly visible. So many people even lost their lives during the sport. They have also the tails bitten and twisted, and their eyes and noses usually is filled with irritating chemicals and also given toxic drinks before the sport. This came after the Animal Welfare Board of India. Now this is a statutory body under the center, and the animal rights group, that is a People for Ethical Treatments of Animals or PETA, provided documentary evidence to the Supreme Court suggesting that Jallikattu sports like Jallikattu and Kambala physically and mentally tortured the animals. Jallikattu, let me tell you, is a bull-taming sport, and it is traditionally being played in Tamil Nadu as a part of the Pongal harvest festival. The festival is a celebration of nature and also gives thanks for giving for the bountiful harvest, of which cattle worship is an important part of this. The practice of Jallikattu has been long contested, with animal rights groups and court expressing concern in the manner in which these animals or these bulls are actually treated, and the dangerous nature of the sport that sometimes causes death and injuries both to the animal as well as human participants. Now, in the present case, the petitioners have challenged the Tamil Nadu amendment that allowed Jallikattu, contesting that the central law prohibits cruelty to animals and that there could not be an amendment brought to the act which perpetuates cruelty to the animals. The plea also names the state of Karnataka, Maharashtra as parties to the case, since they also have similar bull-related sports. So what are the amendments that have been brought by these states? Now, in 2017, Tamil Nadu amended this act to allow Jallikattu in the state. The amended act sought to preserve the cultural heritage of Tamil Nadu and also to ensure survival and well-being of the native breeds in the state of Tamil Nadu. Now, this came after the 2014, as I have reminded you earlier. So what are the petitions now regarding? The initial petitions by the Animal Welfare Board of India was actually to tell the states, to ask the Supreme Court to ask the states to comply with the 2014 judgment of the Supreme Court under the Welfare Board of India versus Nagaraja, and the passage of the Prevention of Cruelty to Animals Act in 2017 now led to a reverse scenario where now the petitions had to be filed to actually ask the Supreme Court to do away with this amendments that have been brought about, because they say that the amendments perpetuate the cruelty to animals by allowing the festive or the bull taming sports to be continued in the name of culture. Supreme Court, however, upheld the amendments made by the Tamil Nadu, Karnataka and Maharashtra governments, saying that it was done under the list 3 of the list of legislations in Schedule 7, and said that it allows the traditional bull taming sports of Jallikattu, Kambala and bullock-cart with certain protections offered, and also certain rules to be followed during the sport. So therefore, the bench said, the 5-judge constitution bench headed by K.M. Josephs held that the state amendments did not violate the constitution and also the Supreme Court judgment of 2014 which banned Jallikattu. Then it also left the matter to the parliament and said that these were valid legislations, and Jallikattu issue was a debatable issue and therefore must be decided by the parliament, that is the Lok Sabha. Making decisions which require social and cultural analysis in greater detail cannot be taken up by the judiciary, and this was the same argument laid down by the Supreme Court recently when it said that it could not have the same-sex marriage to happen under the Special Marriage Act, and therefore it involves social questions, and this should be debated in the parliament and not the judiciary. And therefore it said that the judiciary can actually be a facilitator to protect the rights of the same-sex couples. So this is what is being said even here also. It says that culture and social and cultural analysis should be done in the legislature, that is the parliament, and not the judiciary. Now, the 2014 erstwhile ruling held that bovine sports were contrary to Section 3 of the Prevention of Cruelty to Animals Act 1960, and which related to the duties of the persons having charge of these animals or the buffaloes which are used in the sports, and also it defines animal cruelty respectively. So whatever it found in the sport violated the provisions of this act, and therefore it was banned in 2014. Similarly, in 2016, in the aftermath of the 2014 judgment, the Ministry of Environment, Forest and Climate Change prohibited the exhibition or the training of these bulls as performing animals. However, an exception was carved in the notification which specified that the bulls might still be trained for performing animals in events such as the Jallikattu in Tamil Nadu according to the customs and the culture of different communities. It also specified that this exception is subject to conditions like reducing the pain and the sufferings of the bulls utilized in the sports, and this is what the Tamil Nadu government has actually done. It has brought amendments to the central law in 2017 upholding the rules provided in the 2016 notification by the Ministry of Environment, Forest and Climate Change. Now, the Constitution bench was also tasked with deciding whether Tamil Nadu could preserve Jallikattu as a cultural right under Article 29 of the Constitution. So, under Article 29, any section of citizens residing in the territory of India or any part thereof having a distinct language, script or a culture of of its own has the right to conserve the same. And this is what Tamil Nadu, Maharashtra and Karnataka are arguing. They say that they have the right to preserve this culture of bull-taming sports, which has been a part of the society of the Tamil Nadu and the states from many centuries and eras dating back to the Pandyan times. So they said that they have the right to protect their culture and sport, and therefore they have made certain amendments to the central law to reduce the cruelty and also the rules to be followed to ensure that pain is not inflicted to the animal. So what did the Supreme Court say? Now the court said that the 2017 amendments that have been brought by the Tamil Nadu, Karnataka and Maharashtra do not violate Article 51AG and AGH. These are the fundamental duties which impose duties on Indian citizens to protect the environment and also develop scientific temper, humanism, spirit of inquiry, reform respectively. Further, it also held that the amendment did not violate Article 14 and 21 of the Constitution and has left the matter whether Jallikattu is a part of the culture of India and the society of Tamil Nadu to the Parliament. So I hope this information was really helpful to you all to understand what exactly the Supreme Court said with regard to upholding the amendments brought by the Tamil Nadu, Karnataka and Maharashtra government with regard to taming of sports after banning it in 2014. So, and this is really helpful from the constitutional provisions point of view with regard to the UPSC GS paper 2 and fundamental rights and fundamental duties as well. I shall see you in my next post, and until then, it's very happy learning.